Greetings and welcome everyone to the IU McKinney School of Law. I'll start off with our land acknowledgement. Founded in 1969, our campus and our school stand on the historic homelands of Native peoples. The Miami people, the Potawatomi people, the Shawnee people, and more recently, that of a vibrant Black community, also displaced. We pay respect to elders, both past and present, and we thank them for their hospitality. We, the present stewards of the land, honor them as we live, work, and study here on this campus and at the IU Robert H. McKinney School of Law. So, all, it is wonderful to see you here for our very first Bayh Lecture in-person Bayh Lecture, I should say, since 2018. You all know what happened in the intervening years. So this lecture was established here at IU McKinney School of Law in honor of the late US Senator Birch Bayh and in recognition of his long and distinguished career in government. The lecture series is made possible through the generous contributions of the Friends of Birch Bayh. In addition, we're very grateful for the support over the years of Senator Bayh's son, Chris, who's here tonight, and his mom, Kitty Bayh, who unfortunately was not able to join us in person, but who has been a great friend of this event and of the law school generally. Senator Bayh's accomplishments in the Senate were history-making. These include landmark legislation, such as the Disaster Relief Act that became the foundation for FEMA, Privacy Protection Act, the Juvenile Justice and Delinquency Prevention Act, the Bayh-Dole Act, the focus of last year's Bayh Lecture. As well, Senator Bayh is the only person since James Madison to draft multiple amendments to the US Constitution. The 25th Amendment regarding presidential and vice presidential disability and succession, creating the framework for the presidential transition. The 26th Amendment lowered the voting age from 21 to 18, and the Equal Rights Amendment, which has not yet become law. Today's lecture commemorates the historic legislation known as Title IX, legislation that was over 200 years in the making. As Kitty Bayh stated in her speech to the ERA Coalition earlier this year, and I'm quoting, "In March of 1776, Abigail Adams wrote her now famous letter to her husband, John, while he was at the Continental Congress, writing what would become the Declaration of Independence. Understanding the moment, Abigail wrote, quote within a quote, as you know, by the way, in the new code of laws, which I suppose it will be necessary for you to make, I desire you would remember the ladies and be more generous and favorable to them than your ancestors." He didn't remember. His cohort did not remember. But 196 years later, Birch Bayh remembered. In 1972, Senator Bayh authored and passed two historic pieces of legislation, Title IX to the Higher Education Act and the aforementioned Equal Rights Amendment. 2022 is the 50th anniversary of the enactment of Title IX, which prohibits discrimination in schools based on sex. The legislation consists of only one sentence, and how powerful is that single sentence? No person in the United States shall, on the basis of sex, be excluded from participation in, be denied the benefits of, or be subjected to discrimination under any education program or activity receiving federal financial assistance. How broad its scope, and we still live with its legacy today. Tonight, we're privileged to welcome a speaker who is uniquely qualified to speak on the topic. Jeanette Lim Esbrook is a civil rights attorney with over 50 years experience in civil rights policy, litigation, and administration. Her career is remarkable, and I will only touch on highlights. She served as acting assistant secretary in the Office of Civil Rights during two presidential transitions, 1992 to 93, from President George Herbert Walker Bush to President Bill Clinton, and then 2000 to 2001, from President George W. Bush to President Barack Obama. As a Justice Department attorney, she litigated numerous gender and race cases, including the admission of women to South Carolina's Military College of the Citadel, a landmark 14th Amendment and Title IX case. Her policy work in the Office of Civil Rights included trailblazing work in Title IX, sexual harassment policy development, and Title IX requirements for equity in intercollegiate athletic programs. Currently, she is a board member of the University of Michigan's College of Education and the vice president for legal affairs for the Clearinghouse on Women's Issues in Washington, D.C. Finally, she's the daughter of Chinese immigrants and has firsthand family experience with how educational attainment can provide an avenue for improving one's future. Welcome, Ms. Lim Esbrook. Our speaker will speak and then we'll be open to questions. Thank you all.
Thank you, Dean Bravo, for that wonderful introduction. I'm truly honored today to be here to celebrate the great Senator Birch Bayh. He spent, and to honor the 50th anniversary of Title IX. The Birch Bayh represented Indiana from the great state of Indiana for 18 years, from 1963 to 1981, a remarkable 18 years of service. As the dean explained to you, he authored 2 amendments. The only other person who offered more amendments was James Madison. And the two amendments, as the dean mentioned, created it was the 25th Amendment establishing procedures for the transition of power in the case of death, disability, or resignation of the president. And the 26th Amendment, as she mentioned, that lowered the age of voting to 18. Senator Bayh voted in favor of the Civil Rights Act of 1964, as well as the Voting Rights Act of 1965. He led efforts to ratify the Equal Rights Amendment, and in 1972, he joined with Representatives Edith Green from Oregon and Patsy Mink from Hawaii to sponsor Title IX, which provides, as the dean said, in a simple sentence of 37 words, no person in the United States shall, on the basis of sex, be excluded from participation, be denied the benefits of, or be subjected to discrimination under any education program or activity receiving federal financial assistance. 1972 was a banner year for women. The first issue of Ms. Magazine was published. Helen Reddy's I Am Woman, Hear Me Roar was at the top of the 1972 charts. The children's book, Free to Be You and Me, written by TV star Marlo Thomas, was published. The Equal Rights Amendment was approved by the Senate on March 22nd with efforts from Senator Bayh, and Title IX was signed into law by President Nixon. 50 years later, this year, only one of these 3 fundamental rights of women remains standing, and that is Title IX. I forgot to mention that the Supreme Court announced Roe v. Wade. And again, let me say, only one of these 3 fundamental rights of women, Title IX, remains. Senator Bayh was featured. I was watching a 50th anniversary celebration on ESPN, and the coverage was on a 2002 congressional hearing where Congress was revisiting whether Title IX was significant, particularly in revenue sports. Here's a quote from Senator Bayh's testimony. Don't tell me women are not interested. Very much like the movie Field of Dreams. If you build it, they will come. Title IX built it, and women have been coming and coming and coming and continue to come as long as they have the opportunity to do so. For me, the civil rights movements of the 1960s and the 70s had a personal impact on my career. I had received a Bachelor of Science degree from the University of Michigan with a major in chemistry and a master's degree in medical genetics from the University of Wisconsin, all Big Ten schools. And my career was to be a research scientist in genetics, in medical genetics. Then the civil rights movement really got to me. I was determined to go to law school and become a civil rights lawyer. And I did. I received a JD degree from Temple University Law School in Philadelphia. And I found that my education as a scientist and training have added to my ability as a lawyer. I use the scientific method and approach to analyze jurisprudential law, just as I analyze scientific laws. And I eventually used my legal education, as Dean Bravo said, to become a federal government civil rights lawyer in the Departments of Justice and the Department of Education in the Office for Civil Rights. And among the civil rights laws I enforced was Title IX. My plan today is to review the history of the passage of Title IX and what rights are protected by Title IX. I will share legal challenges, and there were many, to Title IX, and how those challenges were met. I'll specifically review the development of Title IX athletic and sexual harassment policy and case law. And finally, I'm going to close with discussing some of the developing issues and the future of Title IX, including trans athletes and NIL, name, image, and likeness. First, the history of Title IX. Representative, as I said, Edith Green, Patsy Mink, and Senator Bayh, along with Bernice Sandler, a feminist activist, were the leaders of getting Title IX enacted. Representatives Green, Mink, and Senator Bayh considered amending Title VII of the Civil Rights Act, which, among other provisions, prohibits workplace discrimination on the basis of race and sex in federally funded programming. But they found that including an education provision was politically too difficult. But then the reauthorization of the 1965 Higher Ed Act in 1972 provided an opportunity to add a ninth title. Edith Green held hearings on Title IX, and it became part of the Higher Education Amendments of 1972, with the vision that more women would be granted admissions to higher education institutions. It was signed by President Nixon on June 23rd, 1972. Excuse me. In 1975, the Department of Health, Education, and Welfare implemented Title IX by publishing Title IX regulations, found at 34 Code of Federal Regulations, Part 164. But prior to the enactment of Title IX, Bunny Sandler, one of the activists who supported Title IX's enactment in 1970, and members of the Women's Education Equity, the Women's Equity Action League, WEAL, WEAL, discovered Executive Order 11246. This established requirements for government contractors. It was called a contract compliance executive order. This originated, it was at one time, years ago, it was called the Philadelphia Plan. Almost all universities have contracts with the federal government, either through grant contracts or awards. The executive order requires contractors to identify underrepresentation of women in their workforce and to take affirmative action to overcome that underutilization. We'll file complaints against numerous federal granted universities with the Department of Labor, the Office of Federal Contract Compliance Programs. That office also enforced Executive Order 11375, requiring affirmative action to hire any underrepresented minorities in their workforce and to take affirmative action to overcome that underutilization. In 1972, this is before I went to law school, I was hired to implement the contract compliance executive orders in the provost office at the University of Delaware. And when HEW published the regulations in 1975, at that time I was in law school, we decided to hold hearings, inviting the school deans and department chairs to comment on these newly published Title IX requirements. We wanted to see what effect it would have on our university. We received some enthusiastic support as well as challenges to the regulatory requirements. One of the largest challenges came from the athletic department, a foretelling of the national challenges to athletics to come. The lack of Title IX support by the athletic department affected me personally, basically on my tickets to the Delaware Blue Hens football games. They had a winning football team and I was a fan. My husband and friends were fans. And we always got tickets because I was from the provost's office, right? On the 50-yard line. Suddenly, after the Title IX hearings, we got our tickets and all of a sudden we were moved to end zone seats. So my good friends, including the U.S. District Court Judge for Delaware and his wife, gracefully shared the seat changes with us, acknowledging that they were enduring this for their 3 daughters. I want to turn now to some other legal challenges to Title IX, which in 1979, when Geraldine Cannon was denied admissions to the University of Chicago Medical School on the basis of her sex and her age of 39, she sued on the basis of sex and age discrimination. The medical school denied admissions to any applicants in their 30s, as they asserted that older students were not likely to be practicing medicine long enough, and it didn't really pay to use the resources needed to educate and train medical students. Geraldine Cannon claimed that policy had a disproportionate impact of age on women who more frequently delayed advanced degrees, such as medical schools, because of pregnancy and family responsibilities. Adding to her claim, she provided actuary tables showing that women generally had longer life expectancies than men, rebutting the medical school's claim of a shorter length of practicing time of medicine. The district court held that under Title IX, the exclusive statutory remedy created by Congress was the termination of federal funds. Accordingly, they determined that Geraldine Cannon had no private right to sue, and she had no standing under Title IX. The Seventh Circuit affirmed the district court's opinion. On appeal to the U.S. Supreme Court, They reversed the lower court's opinions and determined that Title IX did provide an individual right to sue, and a cause of action was granted Geraldine Cannon. And in Cannon versus University of Chicago Medical School, 441 US 677, 1979, you have a page of citations, and it's there. SCOTUS required the admission of Geraldine Cannon to the medical school. Another Title IX and 14th Amendment admission case involved military academies. In 1975, President Gerald Ford signed Public Law 94-106, allowing women to be admitted to all male United States military academies, the Naval Academy, West Point, the Air Force Academy, and the Coast Guard Academy. It was not until 1990 that women began to seek admission to public state military academies, including the Virginia Military Institute and the Citadel in South Carolina. At that time, I was a senior litigating attorney in the Department of Justice and a member of the legal team litigating the Title IX and the 14th Amendment case against the Citadel. Both the Citadel and VMI received federal and state public funds. Those funds are generated from taxes that are collected from both men and women. So men and women should be able to benefit from those taxes. Even when the Naval Academy, West Point, Air Force Academy, and the Coast Guard Academy had enrolled women for 21 years, these public higher education institutions limited admissions to men only. In response to lawsuits by women, Virginia, the states of Virginia and South Carolina decided to open an all-women military academy in their respective states to provide what they described as identical military education. The women, citing Brown v. Board of Education, asked the Supreme Court to review their case. The prestige of a degree from those institutions, those two military academies, could not be replicated in any new created institution, they claimed. A Citadel graduate wearing that big Citadel ring indicating graduation immediately had access to a network of power structure in South Carolina. This gave this graduate access to political office, membership in banks and large corporation boards. This was enhanced by virtue of a Citadel degree. And in US versus Virginia, in the 1996 case, the Supreme Court held in an opinion written by Ruth Bader Ginsburg that the state of Virginia, offering an equivalent opportunity for women by virtue of establishing the Virginia Women's Institute for Leadership, lacked the equivalent benefit and prestige of a VMI degree. Separate was not equal, and the category exclusion of women from VMI was not remedied by creating the Women's Institute. Equal protection guaranteed by the 14th Amendment was denied to women, Ruth Bader Ginsburg said. Our legal team was in court on that same day the VMI opinion was announced. We were prepared to present the government's case challenging the Citadel. And our judge said, quote, "Guess what, folks? The Supreme Court has spoken, and I'm asking you justice attorneys and the Citadel administrators to retire and work together for a corrective action plan so that Citadel will enroll women." Our combined team spent months working out the details of an enrollment and assimilation plan. An interesting debate that I want to share with you rose out of the decision to provide for the women graduates at the Citadel a smaller ring that was originally designed for wives and mothers of the male cadets, called the Sweetheart Ring. These were going to be provided to the Citadel women graduates. I raised that as an unacceptable and demeaning mark of second class, and was actually different treatment based on sex. But my colleagues thought I was making this too big a deal compared to these other aspects that really was hard to work out. These included physical standards, measuring strength and speed that women had to meet for admissions, originally for promotion, and finally for graduation. I was persuaded to reluctantly drop the ring issue. At the court's final session, our plan was submitted, and complimenting our due diligence and hard work, Judge C. Weston Houck adopted our plan with one comment. He said, and I quote, "It's about that ring." He recognized the significance of the Citadel ring and required that women graduates receive the same sized ring as male graduates. I was happy with that. I remember seeing the second Citadel graduate, a Czechoslovakian immigrant named Petra Lovatinska. She graduated in the class of 2000. And I was thinking how insignificant the Citadel Sweetheart Ring would look on her large finger compared to the usual Citadel ring which she received. She became a member of the U.S. Marine Corps. Title IX is well known for its impact on women and girls' athletics participation in sports. In 1979, after successfully increasing participation of girls in high school, HEW turned to the issue of women's participation in intercollegiate athletics and published guidance on Title IX regulations in intercollegiate athletics, the infamous three-part test. The Office for Civil Rights had received numerous complaints on the lack of opportunities and unequal treatment at numerous universities. At that time, I was a recent law school graduate and was hired by HEW General Counsel. This was 1979, and I was assigned to work on Title IX. My first assignment was to a policy group formed to flesh out the 1979 Intercollegiate Athletic Policy Standards and develop an investigative response to the numerous complaints filed under this guidance. Many of the complaints were filed against universities with large athletic programs, including the University of Michigan, the University of Wisconsin, University of Indiana. The DC policy group trained investigators from OCR's 10 regional offices. Our DC headquarters policy group were women lawyers with very little athletic sports experience. We were lucky to discover our regional investigators, men who had experience playing high school and college sports, and they added to our understanding of college athletics, and especially to the National Collegiate Athletic Association. I actually met my 6'5" husband, ex-basketball player, who is here today. It's right there. I'm about 5 feet tall. And my limited sports experience at that time was cheerleading. I've since run a marathon. We formed teams to investigate the complaints and identify many issues of noncompliance, set out letters of findings and negotiated remedies in the form of compliance agreements based on that 1979 intercollegiate policy. In 1980, HEW was divided into two agencies, the Departments of Health and Human Services, and the Department of Education. Under the newly created Department of Education Office for Civil Rights, we continued to enforce the 1979 athletic policy. But in 1984, we ran into a buzzsaw, a monumental legal challenge to education's jurisdiction over intercollegiate athletic programs. Excuse me. OCR Ed completed an investigation of the University of Alaska. And I was traveling to Fairbanks, Alaska in February 1984, prepared to deliver a letter of finding and to begin negotiating a settlement agreement to equalize women's athletic programs with the men. During my layover in Seattle, I was contacted by my headquarters office and directed to return to DC immediately. That morning, the Supreme Court announced their opinion in Grove City versus Bell, holding that Title IX applies only to programs or activities that directly received or benefited from federal assistance and did not apply across the entire institution. I was not equipped with any data to show that federal funds went directly to and directly benefited the university's athletic program. So I returned empty-handed. There followed a 3-year period with no reviews of Title IX intercollegiate athletic complaints. But then in 1987, in response to the Supreme Court's Grove City opinion, Congress passed the Civil Rights Restoration Act, which specified that entities receiving federal funds must comply with civil rights legislation in all of their operations, including athletic programs. Emphasis on all, thus amending Title IX of the Education Amendments of 1972. Congress also clarified that the Civil Rights Restoration Act applied to the Civil Rights Act of 1964, the Rehabilitation Act of 1973, and the Age Discrimination Act of 1975, and applied to all programs and activities of a federal fund recipient. Ed OCR once again enforced the Title IX intercollegiate athletics policy with the following results. In 1972, 90% of intercollegiate athletics were men, and only 10% were women. Today, the percentage of women college athletes is 42% and men 58%. The U.S. News and World Report in a June 6, 2022 article stated that girls' high school participation rate is 10 times greater today than it was prior to Title IX. An increase of more than what they claimed was 1,000%. 1 in every 5 girls plays sports today. In 1972, it was 1 in 27 girls. The YWCA in November 2021 reported that participation in athletics resulted in an increase in academic success for girls, education degrees, employment, leadership, CEOs in business, and academic leadership, college, university deans, department chairs, and even presidents. The report also indicated decreases in teen pregnancy, obesity, depression, and feelings of low self-esteem and negative body image. We cheer the success of women Olympians, which many have attributed to Title IX. Finally, after years of winning gold medals, the U.S. women's soccer team won their lawsuit against the U.S. Soccer Federation with support from the men's U.S. soccer team. They settled their lawsuit alleging violations of Equal Pay Act and Title VII and received an award of $24 million and a pledge that they will be the same as men as the men's teams in Megan Rapinoe et al. Versus United States Soccer Federation. Recently, a UCLA basketball player, Kaija McCullough, reported on an outrageous difference in training resources. She claimed and showed that men had a fully equipped training room at UCLA, the size of a basketball court, and fully equipped with multiple units of training equipment, while women had a single set of weights in an equipment storage room smaller than a locker room. The media picked up on this, and all of a sudden, UCLA found the resources to provide the women's basketball team a decent and fully equipped training room. Over the past 50 years, Title IX has gained a reputation and is best known for athletic opportunities. And that's a hard reputation to shake. While Title IX was originally enacted to improve access to education for women, to open doors for better and higher paying employment, to provide opportunities for women to become engineers, doctors, lawyers, professors, CEOs, CFOs, etc. Yet another issue has come forward and is well known as a Title IX issue, and that is sexual harassment. It has been increasingly in the news. In the early 80s, OCR regional offices began receiving complaints of sexual harassment that were becoming recognized as Title IX violations. A complaint received by OCR's Denver regional office in 1980 was from a woman student at a state university. The complaint was that in order to receive financial aid, the financial aid officer of that university required the student to sit on his lap while he acquired information about her eligibility for a student scholarship or a student loan. When headquarters was asked by our regional office how to deal with that complaint, I was assigned to develop policy and investigate guidance and investigative guidance on these new types of complaints. This was 1980, and these were brand new, not only with us, but with the EEOC, with the Department of Labor. This resulted in an August 31st, 1981 OCR policy memorandum affirming Title IX jurisdiction over sexual harassment complaints. Early cases that I relied on was a 1979 grade dispute at Yale University, Price v. Yale and Alexander v. Yale. The plaintiff's students alleged that they received diminished grades in their courses because they refused to respond positively to their professor's sexual overtures. Based on these early cases, the following working definition was adopted by OCR. Quote, sexual harassment consists of verbal or physical conduct of a sexual nature on the basis of imposed on the basis of sex by an employee or an agent of a recipient that denies, limits, provides different, or conditions the provision of aid, benefits, services, or treatment protected under Title IX. Also, in 1992, the Supreme Court held in Franklin versus Gwinnett County that monetary damages are available under Title IX sexual harassment cases. Sexual harassment continues to be a serious matter, especially in higher education institutions. With the Me Too movement brought on by the allegations against and the trials of Harvey Weinstein, there is a perception of changes around the culture of sexual harassment and sexual violence. But then another scandal about an abusive teacher, coach, or doctor comes to light. Sexual harassment as committed by employers, teachers, or professors frequently is the power of one party over another and is often framed as sex for grades or sex for jobs. Sexual violence against women athletes has finally received recognition in the Michigan State case of team doctor Larry Nassar abusing gymnasts for over 18 years before an FBI investigation outed him. He is currently in prison for 60 years. And recently, the National Women's Soccer League investigation by Sally Yates, former U.S. Department Attorney General, revealed reports of coaches sexually assaulting their players. Her October 22nd, 2022 report found that sexual misconduct and emotional abuse are systemic and runs through every level of women's and girls soccer in the U.S., from youth leagues through collegiate and professional teams. This was a shocking revelation to many parents and to fans. The Title IX sexual harassment policy eventually formed the basis of OCR anti-harassment policies based on disability and based on race. Harassment is one of the few policy areas where Title IX and sex discrimination was the leader in establishing civil rights law and civil rights policy. Typically, it's Title VI of the Civil Rights Act and race discrimination that is at the forefront of developing discrimination policy and law. Under the Trump administration, the Secretary of Education, Betsy DeVos, rescinded many of the sexual harassment policies that had been developed during the 40-year period between 1980 and 2020. In 2020, Secretary DeVos announced a new sexual harassment rule barring universities from using a single official to investigate and judge complaints, and instead created a judicial-like process in which the accused has the right to a live hearing and to cross-examine accusers. She described it as a way to protect due process and said, "Today, we release a final rule that recognizes we can continue to combat sexual misconduct without abandoning our core values of fairness, presumption of innocence, and due process." Several appellate courts have permitted students disciplined for sexual harassment, primarily men and boys, to sue their schools for reverse sex discrimination and for defamation. Due process of sexual harassment grievance procedures has become a very contentious subject. President Biden's Executive Order 14021 of March 2021, entitled Guaranteeing an Educational Environment Free from Discrimination on the Basis of Sex, including sexual orientation or gender identity, resulted in a comprehensive review of all Title IX regulations, including the 2020 sexual harassment regulations promulgated by the Trump-DeVos Education Department. Numerous listening sessions and meetings with students, parents, and educators in elementary, secondary, and post-secondary schools, state government representatives, advocates, lawyers, researchers, and other stakeholders were held by ED and OCR. Proposed changes to the sexual harassment regulations have now been published in a Notice of Proposed Rulemaking, NPRM, this summer. It is in the Federal Register at 87, number 132, July 12, 2022. Comments to the NPRM to the Department of Education had to be received by September 12th, 2022. A final regulation taking into account the comments received has not been published yet. The previous administration's 2020 sexual harassment guidance, which are still current, limited jurisdiction to only events that occur in actual education programs, only in classrooms, only on campus, only in campus buildings such as dormitories. One of the major changes the NPRM proposes is that jurisdiction over sexual harassment and violence will include complaints that occur off campus, such as at a fraternity or a sorority event, at off-campus housing, at studies abroad locations, and online stalking and harassing. As long as the allegation claims the denial of the ability to participate in or benefit from an education program or activity. The NPRM addresses how to investigate complaints of sexual discrimination by proposing flexibility and permits a choice for grievance procedures by universities. These choices include holding a formal hearing where both parties are present and cross-examinations are made by a representative. Another option is conducting an investigation by an official where parties meet separately with the decision maker and answer questions, including those submitted by all parties. In all procedures, including these two options, all parties have the right to review all relevant information, and due process to all parties must be guaranteed. Individuals who have experienced harassment have expressed difficulty deciding to complain about harassment and simply being believed. Many university representatives regarding these choices have stated that holding formal courtroom-like procedures is not consistent with their educational and learning environment, and that it was too polarizing. Supporters of the DeVos rule said it would restore balance and fairness to proceedings that too often tilt in the favor of the accusers. Survivors rebutted, again, the difficulty in deciding to file a complaint and talk openly about sexual abuse and be subjected to questions about their lifestyles and harassment because they could not be believed. In 1604, William Shakespeare, when he wrote the play Measure for Measure, knew the difficulty of harassment survivors being believed. I was amazed to read about this. In Shakespeare's play, Isabella, a novice nun and sister of Claudia, facing execution, pled for mercy from Judge Angelo to commute her brother's execution. Angelo agrees to commute the execution only if Isabella will consent to having sex with him and giving up her virginity to him. Isabella refuses and threatens to publicly expose his lechery. But Angelo haughtily asserts, quote, "Who will believe thee, Isabella?" Even in 1604, William Shakespeare knew how difficult it is for victims of sexual harassment to be believed. Now, I'm going to close with some thoughts about the future of Title IX and women and athletes. The issue of participation of trans athletes has been under considerable examination and discussion. Let me first explain some terms. A trans athlete is one who has undergone a change in gender identification, some including hormonal treatment. An important consideration in this dialogue to many. Cis athletes, cis athletes, are athletes who are the gender of their birth. Leah Thomas, a transgender woman who swam for the University of Pennsylvania, has fueled this debate. Before Leah Thomas transitioned through hormone therapy, she ranked among men 554th in the men's 200-yard freestyle in swimming. She tied for 5th in this race in the women's 2022 NCAA championship. She ranked 65th in the men's 500-yard freestyle, but won the title as a female. The NCAA requires a year of hormone-suppressing therapy to bring down testosterone levels to diminish the inherent biological advantage held by the athlete assigned male at birth. Leah Thomas followed this requirement. There is a debate over the science of testosterone enhancement, and the debate concerns the transgender female athlete, not the transgender male athlete. It's well recognized that girls grow faster than boys and have a size advantage, which diminishes with puberty. Disadvantage disappears quickly as testosterone develops in boys, and dramatic differences in size, strength, speed, and muscle mass are noticeable. 3 months after Leah Thomas won an NCAA Division I swimming title as a transgender athlete, the International Federation Governing Swimming, FINA, F-I-N-A, voted to restrict transgender athletes from competing in elite athletic events. The policy requires transgender swimmers to have completed their transition by 12 years of age and to maintain their testosterone level below a certain level, which is effectively stops their maintenance. And basically, transgender women are barred from competing in elite events, including the Olympics, based on this FINA rule. The Olympics, the International Olympics Committee, defers to each sports federation eligibility rules when deciding participation. The Department of Education Office for Civil Rights, relying on the Supreme Court's 22 decision in Bostock v. Clayton County, recognizes that harassment of LGBTQ individuals is considered sex harassment under Title IX. Following this reasoning, advocates have claimed that prohibiting participation by trans athletes is a violation of Title IX. 18 states, including Indiana, have passed legislation prohibiting trans athletes from participating in athletic competitions. Some cisgender athletes have challenged this by saying this is unfair, seeking to use Title IX against the participation of trans athletes who are really protected, as well as cis athletes by Title IX. In a recent case, Soule et al. Versus Connecticut Association of Schools et al., 4 young cis women competing in track and field in high school claimed that participation of trans athletes had put them at a disadvantage, resulting in fewer opportunities to compete, fewer opportunities to obtain public recognition as champions, and diminished chances at setting recognized records. This could also influence college admissions and athletic scholarships for them, they claimed. Their complaint asked the court to block all transgender girls from competing in women's sports in Connecticut. The Connecticut Association of Schools defended the Connecticut policy of allowing trans girls athletes to participate. The ACLU represented CAS and asked the court to dismiss the complaint, claiming that all 4 plaintiffs have received scholarships to run track in college, and that the trans athletes of which they were complaining did not receive scholarships. The U.S. District Court of Connecticut dismissed the case as moot, as all 4 cis athletes had graduated from high school. The Alliance Defending Freedom has now represented the class of cis athletes in Connecticut, are appealing this case. Many have claimed that there are so few trans athletes who want to compete at that level that this issue has been blown way out of proportion. We shall see. Another hot athletic issue is the unionization of college athletes. The idea of college athletes forming a labor union has seemed far-fetched, but as college athletes score wins in court and the sports business of NCAA grows, labor experts believe a union for college athletes could be formed. A year ago in 2021, bless you, the National Labor Relations Board issued a memorandum, GC 2108, on the statutory rights of what they call players at academic institutions. They decided against using the term college athletes, suggesting that players may meet the definition of an employee under Section 7 of the NLRB Relations Act. The General Counsel of NLRB also opined that NCAA and other conferences may be considered a joint employer along with the college or university. Athletic conferences are considering participation in that regard in the bargaining process, and women advocates have suggested that collective bargaining may be a way to equalize women's programs with men. Are athletic scholarships the equivalent of pay? And if so, could they be equalized through collective bargaining? College athletes and their representatives have raised questions about their rights to benefit from an athlete's name, image, and likeness called NIL. The profits from the sale of shirts, trading cards, and other memorabilia are big business. And in July of 2021, the NCAA enacted their NIL policy, which provides that student athletes are free to enter into any endorsement deals pertaining to name, image, and likeness they see fit, thus allowing college students to receive financial compensation for their respective NIL. In response to many who have raised athletic issues in their comments to the NPRM on sexual harassment, the Department of Education announced that they will engage in a separate rule-making process to address Title IX's application to athletics, perhaps addressing some of these issues I have mentioned today. I will close now with some data to demonstrate that there have been gains in other than athletics. In 1970, women received 43% of all bachelor degrees. After Title IX, that percentage is 57%. Master's degrees went from 39% to 61%, and 10% of doctorate degrees increased to a whopping 54%. Prior to Title IX, women received 8% of all medical degrees, 4% of law degrees, and 4.6% of all other professional degrees. After the passage of Title IX, today these percentages are all close to 50 or even exceeding 50. Prior to Title IX, technical degrees, electrical engineering and computer sciences, women's percentage was zero. After Title IX, it is now 30%. In colleges and universities, the percentage of faculty was 20%, and today it is about 45% full-time or tenure track and 54% non-tenure track. Women college presidents saw a remarkable change from 3% to 32%. In the early 1970s, there were 15 women members in Congress. Today, 146 women account for roughly 27% of all seats, including the first woman Speaker of the House, Nancy Pelosi, and Kamala Harris, the first woman of color to serve as vice president. However, the COVID pandemic resulted in women losing 12.2 million jobs, reversing a decade of job gains. This included 3.5 million mothers with school-aged children who either lost jobs, left, or took a leave of absence, according to the Census Bureau. While men have retained all their jobs lost to the pandemic, women are still down over 1.1 million net jobs since February 2020. Thank you for the opportunity for me to celebrate Senator Bayh and to share time with him. I don't know if we have time for questions. I went on.
Friends, I think we can agree that we received a masterclass today on the topic of Title IX. I know I promised that you would have Q&A. We are past the end of the lecture, but we do have a brief reception out in the atrium, and I hope that you will speak with Ms. Lim Esbrook and ask her some of the questions that you might have asked before. I really appreciate your being here today. I know that she does as well. We learned so much about the history, but also the process of using Title IX has been really terrific. Really a testament to Senator Bayh. So thank you very much. And
You're welcome. Thank you.